This is the second study session of ACT 219 Commercial Law. We are going to be discussing about law of contract. Like you have learned from the first study, where we describe law as a body of rule and regulation governing human activity and conduct, that it is as multifaceted as human activity. This study deals with law of contract. On completion of this study session, you should be able to state the elements of a contract. You should be able to explain what an offer means and how it can be terminated. Likewise, you should be able to explain what acceptance means and how it can be communicated. A contract can be defined as a binding agreement which usually has the incidence of affecting the rights and duties of the parties involved, and such agreement can either be oral or written. For a contract to be acceptable in face of law, there are some essential elements that must be present. These elements are offer, acceptance, and consideration and intention to create legal relation. What is an offer? An offer can be defined as a definite undertaking or promise made by one party with intention that it shall become binding on the party making it as soon as it is accepted by the party to whom it is addressed. The party making the promise is known as the offeror or promisor. The other party to whom it is addressed is known as the offeree or the promisee. An offer can be made expressly or by conduct, but for it to be capable of becoming binding on acceptance, it must be definitely clear and final. However, an offer can be withdrawn anytime before acceptance. There are differences between offer and invitation to treat. While an offer is a definite undertaking made with intention that it is binding the maker if it is accepted, an invitation to treat is a preliminary step in the formation of a contract, as it is just a mere invitation to do business. Example, when somebody displays goods in the catalog, or when there is an auction sales, or where there is a tender or display of goods in shelf in a shop or supermarket. These kind of examples are examples of invitation to treat. Now, an offer can be terminated in the following ways: by revocation, which means that an offer can be revoked anytime before acceptance, but such revocation must be communicated to the offeree before he accepts the offer. The second way by which you can terminate an offer is by lapse of time. An offer can suffer termination if there is no acceptance after an appropriate lapse of time, where the offeror sets a specific period of time for the offer to be opened. Then the offer will terminate after the passage of that period of time. Where no specific period is prescribed by the offeror, the offer will nevertheless terminate after reasonable length of time. Another way we can terminate an offer is by death. In a situation where the offeree has notice of the death of an offeror before acceptance, he cannot validly accept the offer. Where, however, the offeree accepts the offer without notice or knowledge of the offeror's death, whether the acceptance will lead to a contract depends on the nature of the contract itself. Where the contract is one that requires personal performance by the offeror, then the offer will lapse with the death of the offeror, and acceptance in ignorance of the offeror's death will not validate the offer. The last way by which we can terminate an offer is by rejection or failure to meet a condition to which the offer is subjected. An offer is terminated if rejected by the offeree or where it varies or modifies the offer. Now, acceptance. Acceptance is the final expression of agreement to the term of the offer. Acceptance must therefore be absolute, must be unconditional and unequivocal, as well as indicate willingness to contract on the exact terms stated in the by the offeror in his offer letter, and with communication of that assent as the agreement. Where the offeror prescribed a mode of acceptance on terms of contract, only that mode shall be binding. Acceptance by any other mode, even if more expeditious, is invalid and there will be no contract. For example, when an offer is being presented through a post office mail and the agreement is expected to be through a post office mail, but you think post office is not efficient as you expected, so you use a mobile phone to communicate your acceptance. Such acceptance may not be accepted. When there is a purported acceptance which seeks to add to or vary some terms of the offer, it is no more an acceptance because some terms have been varied, but it is known as a counter offer. Now, communication of acceptance. As a general rule, it is essential that an acceptance should be communicated to the offeror, and until it is so communicated, the contract is incomplete. The person accepting must indicate it either by words, that's face to face, or otherwise through telephone, in writing, or by conduct. A mere intention to accept or silence cannot constitute an acceptance. Then acceptance by post. Dispatch of acceptance by post is an exemption to the requirement that notice of acceptance must actually reach the offeror. In the case of acceptance by post, like the example stated earlier, the acceptance is deemed to be complete and the contract to come into existence the moment the letter of acceptance is posted, even if in fact the letter never reached its destination. Once it is properly addressed and stamped, a contract has been established. We have come to the end of this study, but before we go, let's do a quick summary of what we have discussed so far. We have explained elements of contract. We have defined a contract. We have explained what an offer means and how it can be terminated. We have explained the difference between offer and invitation to treat, and we have explained what acceptance means and how it can be communicated. You can read through your study pack to complement your knowledge about the subject discussed in this video. Thank you for listening. See you in the next class.